Constitutional considerations. Finally, the First Amendment could pose constraints on a prosecution. Redacted. IV. Analysis as to redacted. Redacted. Number 4. False statements and obstruction of the investigation. The office determined that certain individuals associated with the campaign lied to investigators about campaign contacts with Russia and have taken other actions to interfere with the investigation. As explained below, the office therefore charged some U.S. persons connected to the campaign with false statements and obstruction offenses. A. Overview of governing law. False statements. The principal federal statute criminalizing false statements to government investigators is 18 U.S.C. 1001. As relevant here, under Section 1000A2, it is a crime to knowingly and willfully make any materially false, fictitious, or fraudulent statement or representation in any matter within the jurisdiction of the executive branch of the government. An FBI investigation is a matter within the executive branch's jurisdiction. United States v. Rogers, 466, U.S. 475-479 in 1984. The statute also applies to a subset of legislative branch actions, viz., administrative matters and investigations or reviews conducted by a congressional committee or subcommittee. 18 U.S.C. 1000 C. 1 and 2. See United States v. Pickett, 353, F. 3D, 6266, D.C., circa 2004. Whether the statement was made to law enforcement or congressional investigators, the government must prove beyond a reasonable doubt the same basic non-jurisdictional elements. The statement was false, fictitious, or fraudulent. The defendant knew both that it was false and that it was unlawful to make a false statement, and the false statement was material. See United States v. Smith, 831, F3D, 1207, 1222, number 27, 9th Circuit, 2017, listing elements. See also 9th Circuit Pattern Instructions 8.73 and CMT, explaining that the Section 1001 jury instruction was modified in light of the Department of Justice's position that the phrase knowingly and willfully in the statute requires the defendant's knowledge that his or her conduct was unlawful. In the D.C. Circuit, the government must prove that the statement was actually false. A statement that is misleading but literally true does not satisfy Section 1001A2. See United States v. Milton, 8 F 3D 3945, D.C. Circuit, 1993. United States v. Dell, 991 F 2D 819 832 through 33, and number 22, D.C. Circuit, 1993. For that false statement to qualify as material, it must have a natural tendency to influence or be capable of influencing a discrete decision or any other function of the agency to which it is addressed. See United States v. Godin, 515 U.S. 506, 509, 1995, United States v. Moore, 612 F3D, 698, 701, D.C. Circuit, 2010. Perjury. Under the federal perjury statutes, it is a crime for a witness testifying under oath before a grand jury to knowingly make any false material declaration. See 18 U.S.C. 1623. The government must prove 4 elements beyond a reasonable doubt to obtain a conviction under Section 1623A. The defendant testified under oath before a federal grand jury. The defendant's testimony was false in one or more respects. The false testimony concerned matters that were material to the grand jury investigations, and the false testimony was knowingly given. United States v. Bridges, 717 F2D 1444, 1449, number 30, D.C. circa 1983. The general perjury statutes, 18 U.S.C. 1621, also applies to grand jury testimony and has similar elements, except that it requires that the witness have acted willfully and that the government satisfy strict common law requirements for establishing falsity. See Dunn versus United States, 442 U.S. 100, 106, and number 6, 1979, explaining the two-witness rule and the corroboration that it demands. Obstruction of justice. Three basic elements are common to the obstruction statutes pertinent to this office's changing decisions. An obstructive act, some form of nexus between the obstructive act and an official proceeding, and criminal, i.e. corrupt, intent. A detailed discussion of those elements and the law governing obstruction of justice more generally is included in Volume 2 of this report. Application to certain individuals. George Papadopoulos. Investigators approached Papadopoulos for an interview based on his role as a foreign policy advisor to the Trump campaign and his suggestion to a foreign government representative that Russia had indicated that it would assist the campaign through the anonymous release of information damaging to candidate Clinton. On January 27, 2017, Papadopoulos agreed to be interviewed by FBI agents who informed him that the interview was part of the investigation into potential Russian government interference in the 2016 presidential election. During the interview, Papadopoulos lied about the timing, extent, and nature of his communications with Joseph Mifsud, Olga Polonskaya, and Ivan Timovi. With respect to timing, Papadopoulos acknowledged that he had met Mifsud and that Mifsud told him the Russians had dirt on Clinton in the form of thousands of emails. But Papadopoulos stated multiple times that those communications occurred before he joined the Trump campaign, and that it was a very strange coincidence to be told of the dirt before he started working for the campaign. This account was false. Papadopoulos met Mifsud for the first time on approximately March 14, 2016, after Papadopoulos had already learned he would be a foreign policy advisor for the campaign. Mifsud showed interest in Papadopoulos only after learning of his role of the campaign, and Mifsud told Papadopoulos about the Russians possessing dirt on candidate Clinton in late April 2016, more than a month after Papadopoulos had joined the campaign and had publicly announced by candidate Trump. Statement of offense 25 to 26, United States versus George Papadopoulos, number 117-CR-182, DDC, October 5th, 2017, Doc 19, Papadopoulos statement of offense. Papadopoulos also made false statements in an effort to minimize the extent and importance of his communications with Mifsud. For example, Papadopoulos stated that Mifsud, a nothing, that he thought Mifsud was just a guy talking up connections or something, and that he believed Mifsud was BSing, to be completely honest with you. In fact, however, Papadopoulos understood Mifsud to have substantial connections to high-end Russian government officials, and that Mifsud spoke with some of those officials in Moscow before telling Papadopoulos about the dirt. Papadopoulos also engaged in extensive communications over a period of months with Mifsud about foreign policy issues for the campaign, including efforts to arrange a history-making meeting between the campaign and Russian government officials. In addition, Papadopoulos failed to inform investigators that Mifsud had introduced him to Timofeyev, the Russian national who Papadopoulos understood to be connected to the Russian Ministry of Foreign Affairs, despite being asked if he had met with Russian nationals or anyone with a Russian accent during the campaign. Papadopoulos statement of offense 27 to 29. Papadopoulos also falsely claimed that he met Polonskaya Polonskaya before he joined the campaign and falsely told the FBI that he had no relationship at all with her. He stated that the extent of their communications was her sending emails just, "Hi, how are you?" That is it. In truth, however, Papadopoulos met Polonskaya on March 24th, 2016, after he had joined the campaign. He believed that she had connections to high-level Russian government officials and could help him arrange a potential foreign policy trip to Russia. During the campaign, he emailed and spoke with her over Skype on numerous occasions about the potential foreign policy trip to Russia. Papadopoulos' statement of offense 30 to 31. Papadopoulos' false statements in 2017 impeded the FBI's investigation into Russian interference in the 2016 presidential election. Most immediately, those statements hindered investigators' ability to effectively question Mifsud when he was interviewed in the lobby of a Washington, D.C. hotel on February 10, 2017. See government sent memo at 6 United States versus George Papadopoulos, number 117-CR-182, DDC, August 18, 2017, Doc 44. During that interview, Mifsud admitted to knowing Papadopoulos to having introduced him to Polonskaya and Timofeyev. But Mifsud denied that he had advanced knowledge that Russia was in possession of emails damaging to candidate Clinton, stating that he and Papadopoulos had discussed cybersecurity and hacking as a larger issue and that Papadopoulos must have misunderstood their conversation. Mifsud also falsely stated that he had not seen Papadopoulos since the meeting at which Mifsud introduced him to Polonskaya, even though emails, text messages, and other information show that Mifsud met with Papadopoulos on at least two other occasions, April 12th and April 26, 2016. In addition, Mifsud omitted that he had drafted or edited the follow-up message that Polonskaya sent to Papadopoulos following the initial meeting, and that, as reflected in the language of that email chain, "Baby, thank you." Mifsud may have been involved in a personal relationship with Polonskaya at the time. The false information and omissions in Papadopoulos' January 2017 interview undermined investigators' ability to challenge Mifsud when he made these inaccurate statements. Given the seriousness of the lies and omissions and their effect on the FBI's investigation, the office charged Papadopoulos with making false statements to the FBI in violation of 18 U.S.C. 1001. Information: United States versus George Papadopoulos, number 117-CR-182, DDC, October 3, 2017, Doc 8. On October 7, 2017, Papadopoulos pleaded guilty to the charge pursuant to a plea agreement. On September 7, 2018, he was sentenced to 14 days of imprisonment, a $9,500 fine, and 200 hours of community service. Redacted. Michael Flynn. Michael Flynn agreed to be interviewed by the FBI on January 24, 2017, 4 days after he officially assumed his duties as National Security Advisor to the President. During the interview, Flynn made several false statements pertaining to his communication with the Russian ambassador. First, Flynn made two false statements about his conversations with Russian Ambassador Kislyak in late 2016, at a time when the United States had imposed sanctions on Russia for interfering with the 2016 presidential election, and Russia was considering its response. See Flynn's statement of offense. Flynn told the agents that he did not ask Kislyak to refrain from escalating this situation in response to the United States' imposition of sanctions. That statement was false. On December 29, 2016, Flynn called Kislyak to request Russian restraint. Flynn made the call immediately after speaking to a senior translation team official, KT McFarland, about what to communicate to Kislyak. Flynn then spoke with Mark McFarland again after the Kislyak call to report of the substance of that conversation. Flynn also falsely told the FBI that he did not remember a follow-up conversation in which Kislyak stated that Russia had chosen to moderate its response to the United States sanction as a result of Flynn's request. On December 31st, 2016, Flynn, in fact, had such a conversation with Kislyak, and he again spoke with McFarland within hours of the call to relay the substance of his conversation with Kislyak. See Flynn's statement of offense. 3. Second, Flynn made false statements about calls he had previously made to representatives of Russia and other countries regarding a resolution submitted by Egypt to the United Nations Security Council on December 21st, 2016. Specifically, Flynn stated that he only asked the country's position on how they would vote on the resolution and that he did not request that any of the countries take any particular action on the resolution. That statement was false. On December 22, 2016, Flynn called Kislyak, informed him of the incoming Trump administration's opposition to the resolution, and requested that Russia vote against or delay the resolution. Flynn also falsely stated that Kislyak never described Russia's response to his December 22nd request regarding the resolution. Kislyak, in fact, told Flynn in a conversation on December 23, 2016, that Russia would not vote against the resolution if it came to a vote. See Flynn's statement of offense 4. Flynn made these false statements to the FBI at a time when he was serving as National Security Advisor and when the FBI had an open investigation into Russian interference in the 2016 presidential election, including the nature of any links between the Trump campaign and Russia. Flynn's false statements and omissions impeded and otherwise had a material impact on the ongoing investigation. Flynn's statement of offense 1 through 2. They also came shortly before Flynn made separate submissions to the Department of Justice pursuant to FARA, F-A-R-A, that also contained materially false statements and omissions, ID. 5. Based on the totality of that conduct, the office decided to charge Flynn with making false statements to the FBI in violation of 18 U.S.C. 1001A. On December 1st, 2017, and pursuant to a plea agreement, Flynn pleaded guilty to that charge and also admitted his false statements to the Department of his FARA filing. CID, plea agreement, United States versus Michael T. Flynn, number 170-6-CR-232, DDC, December 1st, 2017, Doc 3. Flynn is awaiting sentencing. Michael Cohen, IV, or Michael Cohen. Michael Cohen was the executive vice president and special counsel to the Trump Organization when Trump was president of the Trump Organization. Information 1. United States versus Cohen, number 118-CR850 SDNY, November 29, 2018. Doc 2. Cohen information. From the fall of 2015 through approximately June 2016, Cohen was involved in a project to build a Trump-branded tower and adjoining development in Moscow. The project was known as Trump Tower Moscow. In 2017, Cohen was called to testify before the House Permanent Select Committee on Intelligence, HPSCI, and the Senate Select Committee on Intelligence, SSCI, both of which were investigating Russian interference in the 2016 presidential election and possible links between Russia and the presidential campaigns. In late August 2017, in advance of his testimony, Cohen caused a 2-page statement to be sent to SSCI and HPSCI addressing Trump Tower Moscow. Cohen information 2 through 3. The letter contained 3 representations relevant here. First, Cohen stated that the Trump Moscow project had ended in January 2016 and that he had briefed candidate Trump on the project only 3 times before making the unilateral decision to terminate it. Second, Cohen represented that he never agreed to travel to Russia in connection with the project and never considered asking Trump to travel for the project. Third, Cohen stated that he did not recall any Russian government contact about the project, including any response to an email that he had sent to a Russian government email account. Cohen information 4. Cohen later asked that his 2-page statement be incorporated into his testimony's transcript before SSCI, and he ultimately gave testimony to SSCI that was consistent with that statement. Cohen information 5. Each of the foregoing representations in Cohen's 2-page statement was false and misleading. Consideration of the project had extended through through June 2016 and included more than 3 progress reports from Cohen to Trump. Cohen had discussed with Felix Sater on his own travel to Russia as part of the project, and he had inquired about the possibility of Trump traveling there, both with the candidate himself and with his senior campaign official, Corey Lewandowski. Cohen did recall that he had received a response to that email that he had sent to Russian government spokesman Dmitry Peskov. In particular, that he received an email reply and a follow-up phone conversation with an English-speaking assistant to Peskov in mid-January 2016. Cohen information 7. Cohen knew the statements in the letter to be false at the time, and he admitted that he made them in an effort to minimize the links between the project and Trump, who by this time was president, and 2, to give the false impression that the project had ended before the first vote in the Republican Party primary process, in the hopes of limiting the ongoing Russia investigation. Given the nature of the false statements and the fact that he repeated them during his initial interview with the office, we charged Cohen with violating Section 1001. On November 29, 2018, Cohen pleaded guilty pursuant to a plea agreement to a single count information charging him with making false statements in a matter within the jurisdiction of the legislative branch in violation of 18 U.S.C. 1001 A, 2, and C. Cohen information. The case was transferred to the district judge presiding over the separate prosecution of Cohen pursued by the Southern District of New York after referral from our office. On December 7, 2018, this office submitted a letter to that judge recommending that Cohen's cooperation with our investigation be taken into account in sentencing Cohen on both the false statements charged and the offenses in the Southern District prosecution. On December 12, 2018, the judge sentenced Cohen to 2 months of imprisonment on the false statements count, to run concurrently with a 36-month sentence imposed on the other counts.